Come back. This is Newsfile on the Joy News channel. We'll quickly move to our next issue. And already, I mean, our appetite is wet for the budget proper. So we'll be getting into the budget conversations very, very soon. But one thing happened in Parliament, even before the budget was presented, and that's how come the budget presentation came that late. Because the CJ had to be... The CJ nominee had to be approved. The report from the appointment committee was ready. It was laid before Parliament at a plenary. Debates, happened on the report, and then it came down to the approval. And that's where the issues started. And even before that, the minority had staged a walkout during the vetting of the CJ nominee. Honorable Kabiru, where was the minority going with all of this?
Yeah, so thank you. The issue with the nomination of Mr. Honorable
Paul Baffoe-Bonnie,
Justice Paul Baffoe-Bonnie as Chief Justice had his basis on the fact that Mrs. Tokono was removed as the Chief Justice pursuant to Article 146 of the Constitution. That whole Article 146 procedure for the removal of Chief Justice has been challenged by several people. Currently, as we speak, we have not less than about 8 cases on different fora that the people are objecting to the removal of the Chief Justice. The basis for the removal of Chief Justice was based on the fact that a so-called stated misbehavior pursuant to the petition filed with the President by one Daniel Ofori. Daniel Ofori allegations were actually determined with an allegation or alleged breach of the procedures as contained in Article 146. Because as Tokono herself is saying, instead of 1464, she came under 1466 or 7 thereabout, because there was no prima facie determination. And the prima facie determination, she would have the right to be heard. In the prima facie determination, she was not given that right to be heard. That brings the question whether or not her removal was constitutional. That said, we are of the view that Parliament has the right to approve a nomination if there is a vacancy for that matter. And within our standing orders, you can only go in and vet. You cannot be Minister for Finance and you are vetting an appointment for minister, irrespective of the fact that it's been referred to you by the President. So if in the estimation, in the wisdom of Parliament, there is the view that going on with an activity is likely to cause constitutional crisis. For a moment, let's think. If the case before the ECOWAS Parliament for human rights by Jethro Tokono is successful, what becomes of the position of the Chief Justice if he's confirmed? And we cannot have 2 Chief Justices. Now, one will say that by operation of law, there was nothing to start with. So you cannot put something on nothing. Because there was not a position created. Because her removal was not constitutional, was illegal. So Mr. Baffoe-Bonnie appointment couldn't have, be standing the test of time. But the question would then is, are you going to remove him as Chief Justice, or you say that he was not Chief Justice to start with? So to avoid all this confusion, the minority holds the view that, look, the position of a Chief Justice... But
if the minority was minded by the ruling of the Supreme Court in Ekwasi-Fua versus the Attorney General, the court was clear that when it comes to the performance of a constitutional function, the only forum that can stay the hands of the person performing such function should be the Supreme Court. And until the court expressly says so, nobody can stop, the occupant of a constitutional position from functioning as it was.
You see, Vincent Eko Asafo versus the Attorney General has not been determined. It is the procedural or interlocutory matter that was determined. That's the issue of the injunction.
Sure. But the court used that to make the position clear.
That's what I'm saying. And that is, the court needed to determine the substantive case for us to know whether or not her removal, because that is the appropriate forum he was.
Yes.
So the choice of jurisdiction is not in question. That Mr. Asofo at the Supreme Court stating that the removal process of Tokono was illegal is at the right forum. So he was actually being at the right forum. But there was an interlocutory matter, or an issue of injunction, whether he could injunct. And that's what the court was of the view that, look, was the Constitution, so in the spirit of separation of powers, entrust a certain mandate on someone to perform, the court cannot. And they also use the Justice Abdullahi case, which is also recent, to support the fact that once the Constitution has given someone role to play, it's not for the court to, take away that particular rule from it. It is in the exercise. If you're of the view that the exercise is done in a manner that is unconstitutional, then you don't come for that basis to challenge it. But in the course of performing the duty, you cannot injunct the person, so the president cannot be injuncted from performing his duty. That's the argument of the court.
So if the president has performed his duty of issuing the warrant to dismiss the Chief Justice and nominated a new Chief Justice, it presupposes that there is a vacancy, and that's how come the president has done that.
That is the assumption or the presumption of the president in this regard. But as an organ of government, and so as people who make this particular law, and people who are supposed to respect this law, do we have to think like the president? For crying out loud, we are not stooges of the president. We are not, an appendage of the president. Even where the president, there's a feeling in Parliament the president is going wayward. It is for Parliament, which is the conscience of the nation, to step in and hold the president's break, right? It is in that spirit that the minority says that, look, the office of the Chief Justice is not in effective sense vacant, but there's an acting Chief Justice who can perform the role of the Chief Justice, so-called, except that he's not the Chief Justice, because acting Chief Justice is not the Chief Justice. But he can perform any other role that the Chief Justice would have been performing. Why don't you let the person act? If Mrs. Tokono had an opportunity to litigate her matter to his conclusion, why are we in a hurry when the person is actually, is before you or before the laws of the country to ventilate or to make sure that her issues are redressed? Mind you, we're also drawing the president, the speaker attention to the fact that new lawyers call the Subjudice rule. A matter pending before court that if you take a decision could prejudice the interest of the people in court. You should avoid taking that matter. And our standard rules have provided for such that if in your opinion that we take an action which is going to prejudice an interest of a party before the cause or before the laws of the country, stop taking that decision. So the minority making this argument and saying that, look, there are laws. Apart from this case, there is also the case filed by the Center for Citizenship for Constitutionality and then Systems. There are several, even there are high court cases where her right, fundamental human right, the right to be heard, she's alleging that
she was not given
the right to be heard. And this is so common. This is so common that even if you're not a lawyer, you know that even if you go to the Chief Palace with your case, before the chief will make a determination of the matter, he will ask, what do you have to say about the allegation? She's not been given that opportunity. She feels that the process was biased. And we all, using Mr. Paul Baffoe-Bonnie, we hold the view that he's also a conflicted personality. And that being conflicted in this regard, he ought to have also hastened slowly. Why is he conflicted? He is the acting Chief Justice. He is supposed to ensure speedy trial of cases. He is supposed to direct, if he's not directing, the registrar to schedule cases, the registrar of the court to schedule cases. If the registrar is not doing so, he holds the ultimate responsibility to case it. Again, Mr. Baffoe-Bonnie was the person who sat on the case by Vincent.
That threw out the injunction.
Throwing out the injunction. Basically, one will not but to think that there's a clear conflict of interest there because you are the ultimate beneficiary of the fact that the woman should not return. So, putting all this together, we feel like the president could have done it more, even if he wanted to remove the Chief Justice, do it within the dictates of the law. But you see, if you have a president promising the good people of Ghana before even elections, and the party functionaries saying it boldly without remorse, that given opportunity, we are going to remove the Chief Justice, and that the government, when the government came to power, the first thing they were doing was to rape the sanctity of the judiciary. The first thing they could do was to say that the Article 127 of the Constitution do not matter more, which guarantees the independence of the judiciary. And that the government could set a bad precedent. My only worry, as an ordinary Ghanaian...
What did the government do in setting the bad precedents you talk about?
They have opened the floodgate that anyone can come with any trivial issue to occasion the removal of a Chief Justice. What is the breach of law? The stated misbehavior. What is the authority to determine whether an act is a stated misbehavior? The Constitution hasn't defined it, but we can go to previous, Commission of Inquiries. You are talking of moral turpitude. Has it said any of her conduct constitute moral turpitude? We are talking of grave lapse of judgment. Which of her conduct constitute grave lapse of judgment?
But the Constitution set out how the prima facie will be determined.
The prima facie,
and that process was followed.
And that process was opaque, and that there are no even, that's why CJ Wood, Sophia Akufo, actually is advocating for a regulation to guide Article 146 of the Constitution. Because it gives any, mischievous precedent an opportunity. And that's what I'm saying. I'm just afraid that any Chief Justice can be removed without cause. If Mrs. Tokono is made to face this, I am clear in my mind that any Chief Justice of the Republic would be removed
at any
time by any allegation that probably will be brought, and you say, damn, any consequence. If you come to the court, the acting Chief Justice will impanel people and say that they should throw it away. Is that how we want to subject the judiciary to? Look, I have my issues with the judiciary.
You wrap up for me.
I have my issues with the judiciary. And they are personal issues. And I feel like we need to address them to ensure that the only arbiter, the only way that I can go for justice, if a so-called powerful man is coming after me, is the judiciary. And that in the wisdom of the framers of the Constitution, we need to have a judiciary that would actually protect everyone, irrespective of your station in life. We don't want to subject such an institution to the whims and caprices of the executive. Neither do we want to subject it to Parliament. We know the case of State versus Ochery, what Nkrumah did. We are in this country, we read about these things. We have come from a long history of where the judiciary was under attack, the judiciary could not perform its role, and we have moved from that. And the 1992 Constitution has also in a dawn of constitutional supremacy.
Very well.
So that is the issues that the minority have about it. And we think that it's not proper. We feel that Mr. Baffoe-Bonnie is conflicted. We feel that Justice Tokono was not treated fairly, and that a bad precedent, the floodgates have been opened, and that any justice, Supreme Court, Chief Justice is a candidate for removal.
Very well. Honorable Adongo, where do you stand on this? The majority, voted in support of the approval, quite overwhelming, 163 to 69.
The approval of his nomination overwhelmingly by the Parliament of Ghana. All these matters, the Speaker has ruled on them.
The matters raised by...
Yes, the Speaker delivered a communication to Parliament and addressed all these issues. But a child who will cry, if you want to fry all the eggs in this world and give to that child, you say that why is the eggs too much? So we can understand where they are coming from. We're in this country where the judiciary was very predictable. Everybody knew that. That even your passport could not guarantee you your citizenship in this country. Why? Our Constitution knows. Well, it started with your passport. When they said you couldn't register to vote with your passport.
Ghana had.
And that the health insurance card.
Your own passport. And
then it came to birth.
Go and check the constitutional instrument. The passport was replaced with just the Ghana card.
The Ghana card, sure.
In this country, when you are traveling out of your country, what signifies your nationality? Is it not your passport? Mm-hmm. But that doesn't give you the right to vote in our country. And this was a 4-0 type of judiciary, and they were celebrating it. Today, they are the ones crying. Look, His Excellency the President himself can go to, can have a petition against him after winning an election. Mm-hmm. But we still swear him in.
Yes.
Okay? Have we prejudiced the outcome of the constitutional process? I mean, the process?
The election petition presidential.
Because we have sworn in the president? If the court so decides that he was not properly elected and give directives, that swearing in is null and void. Mm-hmm. Is that not so?
That's so.
So, if we swear in a Chief Justice and you go through the process, all the cases that you have, you can bring 1,001 abuse of process. They will be determined. And if they determine that you have a case and give directives, you lose nothing. Is that not the case?
Yes.
So if Justice Bonnie, the case of Tokono is so determined and the court gives directives that he was not properly appointed, what happens? We'll go back to the status quo.
Sure.
So what does Tokono lose? So now we have an acting minister for defense. So there's no vacancy there because there is somebody who is acting. Is that your understanding of who an acting Chief Justice is?
No, that's not what we said, sir.
No, you are saying why are we in a hurry? There's no vacancy. Who says there's no vacancy? There is vacancy at the Ministry of Environment, but there's somebody acting. Is there no vacancy?
There is a vacancy.
There is a vacancy at the Judicial. Somebody is acting. There is a vacancy at Defense Ministry because somebody is acting. Why is it that those other ones, there are vacancies? But in the case of the Chief Justice, an acting is not a vacancy. I just can't understand. You don't need a lawyer to stretch your imagination. Look, they are crying over nothing. And the 1,001 cases in court are just abuse of the process. And we cannot allow any Tom, Dick, and Harry to go to court to injunct Parliament to exercise its own constitutional mandate. Especially when its mandate being exercised does not deny your right if eventually you succeed. So you cannot go around fishing for cases and fishing for people to come to court and think that that will stop Parliament from conducting its own legitimate activities. And the Speaker has made it very clear that he is not going to sit there and recognize some abuse of processes so that we can stop working. He's done his work. The rest is left to the judiciary. Go there and prosecute your case. Mm-hmm. You can bring all the best lawyers in the world. Go and win for Tokono, and then there will be consequential directives. In the absence of that, if the president swears in Justice Paul Baffoe-Bonnie, he is the Chief Justice, so properly nominated, mm-hmm. so properly approved by Parliament, and so properly sworn in.
You don't find his point about the Chief Justice nominee being conflicted an issue?
What conflict?
The fact that the cases pending in court, if determined, may have an effect on whether...
Listen, in the court of the hawk.
Interest is a statement of fact. It's not a conjecture. That you say so doesn't make him conflicted. That the minority says he's conflicted doesn't become the fact.
Okay.
It's a matter of law.
Yes.
So go to court and go and say that the Chief Justice is conflicted.
And the Chief Justice is the one going to determine whether it's conflicted or not. That's the point.
Unfortunately, that's our system.
That is how it is.
What are you saying? What are you saying? So because of that, you want to reconstruct our constitution. You want to reconstruct our constitution to make
the administrative powers
Kabiru the Chief Justice, because the Chief Justice is conflicted, so that a non-conflicted person determines who is empaneled. It doesn't happen like that. Okay. In our country, were we not here when an EC boss was removed for frivolous reasons? Were we not in this country? It didn't set the precedent for removal of future EC bosses. Did it? Did it?
No.
Has the current EC boss been removed?
No.
So where is the Pandora box? That you are prosecuting your case and all you are doing is reducing what is a judicial process into holding of press conferences doesn't change the fact. And the amount of shouting on top of the roof doesn't change the constitutional process. And I can tell you that if Tokono has a case and she truly wins, she has nothing to lose.
Very well, very well.
Yeah, but,
let me thank you.
Because
of time, I'll come back to you. Just give me some few minutes. Let me hear from the two lawyers we have here, and then I'll come back to you. Lawyer Vic, maybe I'll start with you. What do you think with the minority's position on this matter?
See, I have said, I have made my views known on this whole Article 146 procedure and the President's actions. I do not see anything wrong with the President's actions.
Okay.
But he's mandated to take certain steps. And I don't see how, because when you look at the construction of the article, it uses the word shall.
Sure.
So what is he supposed to do? If we don't like Article 146, that's a different discussion. And there are flaws in it. There's a constitutional review commission going on, committee going on now, and they can look at that article in detail to see whether we like the way it works or not. So as long as we have it in the way in which we have it, I don't think any president should be flawed in actually following through with the process. So that's that with Article 146. Now, this we have heard, and we've heard from Honorable Adongutu, who was in Parliament, that the Speaker has ruled on all these matters. So that is it. And we know from all the various decisions, including the most recent ones, that unless you have an explicit judgment or order from the Supreme Court, then you can't stop the executive or Parliament from continuing with its business. Otherwise, you are holding up governance in very, very key arms of government. We have 3 of them. So if you are abusing the process or putting that will paralyze one arm of government, then it's a very serious matter. Are we to wait for ECOWAS to decide on whether our Parliament should proceed or not? We need to really pause and think about this, because it's prone, the system as it is, and I'm not suggesting anyone is trying to abuse, but the system as it is prone to abuse. So somebody has to put their foot down, and we have to respect what the Supreme Court says, which is that if you don't have an explicit judgment or order from them, then nothing can stop the other
performance of a constitutional function.
from going on. We cannot be sitting here and be allowing ECOWAS to decide whether our Parliament moves or not. So we need to sometimes take the politics out of all these things and step back and look at the actual implications of these things. Nobody wants a system where any Chief Justice can just be removed willy-nilly. No, nobody wants that. And if we really genuinely believe that we have opened the floodgates to that kind of thing, I think the whole country, it won't, whether you are NDC, MPP, everybody will get up and be in arms. But for some reason, it's just the minority talking about this. Plus, of course, the former Chief Justice. I want to just say that I wish the minority had been in Parliament to question Justice Baffoe-Bonnie on all the things that they are concerned about. So
they shouldn't have walked out from the
No, they should have asked him these things, and he would have then had an opportunity to explain it to them. And if they were not satisfied, they could have asked more questions. But you were not there. You chose to walk away. And the process continued, as I believe it should have continued. And now there's an outcome, and you are now complaining that this and that. You should have been there. Because whether anybody likes it or not, Justice Baffoe-Bonnie is now the substantive Chief Justice of the Republic of Ghana. And he is in charge of the judiciary. Whether you're an MPP person or an NDC person, you are going to appear in court before him. If you have a matter in the courts, he is ultimately the one in charge of that process. Sure. So it is, I think it's a disservice to their constituents that they didn't show up to represent them in Parliament on that matter. And it's regrettable that they didn't show up. I wish they had. And I want to congratulate the Chief Justice, you know, on
Very
his
well. Very well.
appointment.
Yeah. What do you think? Finally, on this, we are really running against time.
Yeah, so I guess for us, just taking off from what Senior has just said, we should respect the laws and the processes that we set for ourselves at any point in time. I think what's important for us as a country, we will take lessons from history. A very good example is in 1992, after the elections, the opposition refused to go to Parliament.
Yes.
And it followed the stolen verdict and others. What we lost was the quality of debate that we would have expected if the opposition had gone to Parliament. And it was 1996 was a clear reflection of it. When they went to Parliament, we see the quality of debate and the kind of laws that were passed. And so where we have an instance where minority decide not to participate in the process, we lose the benefit of the quality of the scrutiny that would have come out if they had stayed or they participated in the process. So I think for us as a country, yes, we may have some issues, but we should not give the opportunity, or we should not allow these things to fall through, because ultimately, if and when the Chief Justice nominee is now approved, it's sworn in, she's going to take judicial decisions and it's going to affect all of us. But I think what is even more comforting is that the Chief Justice nominee, as he then was, admitted that if there's any judicial ruling that affects his role, he's ready to respect it. And that's something that for us we should have comfort in, that if he's ready to respect it, being the ECOWAS court, the Supreme Court, he's ready to respect it. And so if that's the case, then we participate in the process. And then if subsequently a judicial body takes a decision that affects his position, he's ready to respect it. I think there have been decided cases all over the years, so many years, from Bilson, versus AG, Chikata, among others, even now, Asifwa, that when people are performing their constitutional mandate, unless the Supreme Court, they should be allowed. Otherwise, in some cases, the Supreme Court said there's going to be a meltdown. Because if the judicial bodies are going to explain, the EC is supposed to explain why they are doing, then nothing's going to happen in this country. So then what it means is that for us as a country, we should allow the system to work and reduce the human intervention. And I like the fact that the CJ himself said that he's going to allow AI. So, for instance, we should have a system that is put in place, like the computerized placement system. So,
to do the empaneling?
Yes. If you file your case in court, it's a commercial matter. It involves liquidation or insolvency. It goes to a judge who is in the commercial court with experience in insolvency. Same thing, if you file a case in court, it relates to land. It goes to the land court and it's given to a judge who is experienced in stool matters. Or land has got to do with the stool. It goes there. So it's a system that even when you file, you know the judge that it may end up with. It is not the Chief Justice determining that. So if that computerized system is improved or we install it, and then we have AI performing that, then the risk of us worrying about the fact that the Chief Justice himself is going to empanel the judges on a case that he has interest in, that risk is taken out, because then it's a third party or the registrar's department through the AI system that's empaneling judges. And then we have that independence restored. Because I think lastly, what I would like to say is, when the parliamentary proceedings was going on, before it started, the speaker said something, that there was a conclave. And at the conclave, they had made certain determination. And I think that was a decent way of going about it, that he'd met the leadership of both sides, and he had agreed on something, and the whole debate followed that process. We should have more of such conclave, because some of the spectacle we've seen in Parliament is not very helpful. And so institutions like the Vatican, if they go through the conclave process, there are some people who are nominated that may be adverse findings against them. But to date, you don't know. And so that conclave process helps protect the integrity
Of Parliament.
and the impartiality of not only Parliament, but even our judicial system.
Yeah.
Because some of the things we say about our justices of the Supreme Court, we shouldn't be saying them out there because it affects and impugns on the integrity of our apex courts. And I think that's something that we should...
That's fine. Thank you so much.
Just adding on the back of that, it also encourages trust.
Trust in the whole process. Because of time, and we have two members on the Finance Committee here who are prepared to do justice to the 2026 budget. So we have to zoom straight into the budget conversation. But I would say a big thank you to lawyer Victoria Bright, who would be leaving us. She is an international corporate lawyer and entrepreneur. After this short break, we'll be joined by Dr. Priscilla. I'll do that, don't worry. We'll be joined by Dr. Priscilla Chumesi Baffoe, an economist and senior lecturer at the Department of Economics, University of Ghana. We'll be back and then she will join and the budget conversation will continue. Stay with us.